this is case number 24148320. This is GFL Environmental USA versus Everybody Rides Auto Sales Incorporated. The matter is before the court on the issuance of a subpoena. It is being time for response on the same. Your appearance for GFL, please. GFL, do I have Everybody Rides Incorporated? The court will pass on this matter. I'll come back to it. Does not appear that the petitioner has appeared. I'll come back to it in just a moment.
Oh, sorry, Judge, they removed that.
They remove that?
Yes.
All right, so it's dismissed?
Yes.
The subpoena is dismissed at this time. All right, the court now calls case number 24241223. This is Christopher Kendall versus Peter Carter. The matter is before the court on a petition order to show cause. The show cause is occasioned by the fact that there is an outstanding judgment in this matter. I'm looking for any attorney that is involved in Kendall versus Carter. If there's not an attorney, we'll come to you next. If there's an attorney, let me hear from an attorney first. All right. Mr. Christopher Kendall, if you're here, say something at this time.
Excuse me. He said he's doing graduation. He said he's doing graduation.
Can you hear me, Your Honor?
Oh, there he is.
All right. Thank you. Thank you, Mr. Mr. Kendall. Good morning to you. I'm looking for Peter Carter. Mr. Carter, if you want to say something. Where are you, Mr. Carter? Peter Carter? All right. Mr. Kendall, I'm looking at your subpoena here, and I'm looking at the judgment that was entered in this matter. That judgment was $7,086. That judgment was entered in small claims court, looks like in November. Have you collected any money under the judgment at this time, sir?
No, Your Honor.
All right. And secondly, sir, I'm looking for your proof of service with regard to the subpoena. Were you able to serve the subpoena or have someone serve the subpoena on Mr. Carter, sir?
I had Mr. Yes.
I'm sorry, say that again. You had what?
I had Mr. Brian Mobley serve a subpoena.
Or did you get a return of the subpoena? Because I don't have anything filed with the court saying that the subpoena was served. Do you have a proof of service?
This is the same thing that happened the last time. No, I did not receive any notice back from Mr. Mobley, similar to the last time we met on this case. All
right. So I'm going to need something to show that Mr. Mobley has in fact effectuated service on this matter. I'm looking now. Let me see what's been presented. 1 second, sir.
I can call Mr. Mobley. I don't know if now is the best time. I figured that he had finished all of that. So
yeah, he hasn't filed anything with the court in that regard. So let me ask you this, sir. If I set this up tomorrow morning, you think that you can get a hold of your process server by that time and get a copy of the paperwork? Because the other side.
I will see what I can do, Your Honor.
Yeah, I need to have proof that that person was served, and then I could move the matter to the next step. So let me set you over for 9:30 tomorrow. Let's come back into Zoom, and if you can get that other person to come on, that would be good as well. But what I really need is I need a copy of the proof of service of the subpoena. You understand?
Okay.
All right.
Yes,
so
I do understand, Your Honor.
All right, I'll continue it until tomorrow. Let's see if we can drill down on that and go ahead and get you to the next step. So tomorrow at 9:30, just come back into Zoom and we'll address the matter at that time.
Okay.
Right.
Yes, Your Honor. Your Honor.
Yes.
I will be teaching at that time. I'll just be popping in, saying similar to today.
All right. So yeah, I'm trying to work with you in that regard. So I understand the constraints that you have, but you're at a pivotal point now, and my hands are tied until I can have some return of service, and then we'll be able to move the case to the next step. So I don't want to put it off for a week or anything. There's a proof of service that this guy was actually served. Then he misses today. That means that I can move to the next step and issue a show cause or a bench warrant regarding this matter. So let's try and address that in the morning, 9:30. So make sure you're tuned in, and if I'm not able to connect with you right away, I'll know that you're teaching, and then we'll keep on trying.
Yes, Your Honor. Thank you.
All right. I'll see you tomorrow, sir. Good day to you. All right, this is case number 25-143-486. This is Marlon Braxton versus Portfolio Recovery Associates in LLC. The matter is before the court on the filing of objections to a writ of garnishment. The record should reflect that a judgment was entered in this matter. Looks like for $10,000. Oh, one second. Yeah, a judgment was entered by default for the total sum. Register of action in this file does not link to this. This file says Marlon Braxton versus Portfolio. Also have Vance Payne. Well, let's try to deal with Braxton. The other one. Do I have Marlon Braxton on the show? Do I have counsel for Portfolio on the Zoom? Portfolio Recovery Associates?
This is Mojir Rofik. I am the resident agent and member, but there's no counsel.
All right.
I stand silent. I know.
You said you're a resident agent for Portfolio?
Yes, sir.
And Portfolio has to be represented by an attorney. So do you have an attorney, sir?
There's no attorney, no.
All right. Let me see if I have the other side here. Now, I'm looking at it. Adam Tubb. Was that your attorney at some point?
No.
Do I have, let me look for Marlon Braxton. Do I have Braxton on the Zoom at this time? Marlon Braxton. Court did establish today's date as a pretrial conference. Just one moment. Looking at the status conference was held in this matter on the 28th, and the court set the matter over today for a pretrial conference. The plaintiff failed to appear at the previous conference. The plaintiff is not present at this conference as directed by the court. Therefore, this case will be dismissed at this time, where the petitioner or the plaintiff has failed to appear. The matter is dismissed.
Thank you, Your Honor.
Good day to you, sir. All right, this is case number 06-132-204. This is Asset Acceptance LLC versus Lamal McClendon. The matter is before the court. Looks like I've got it set on for a status conference. All right, well, actually, the matter is before the court on the filing of objections to a writ of garnishment. All right, for asset acceptance, please. Do I have Lamal McClendon on the Zoom? I'm looking for counsel for asset acceptance.
Good morning, Judge. Andrew Perry.
Go ahead with your P number, Mr. Perry.
P69402.
All right, thank you, Mr. Perry. Good morning to you. I'm looking once again for Lamal McClendon. The matter is before the court on the filing of objections to a writ of garnishment in this matter. The garnishment issued as a result of a judgment that was entered by default on the 3rd of November 2006. That judgment was renewed subsequent to that time on 9/15/16. So counsel, I don't see a petitioner regarding this matter. Anything you want to bring to the court's attention at this time?
Judge, I see that there is a Lamal McClendon in the Zoom
Yes, I'm here.
room here with us.
Oh, finally, you say something. I've called for you 3 or 4 times. Good morning to you, Mr. McClendon.
Good morning. Good morning.
All right. So I saw that you filed objections to the writ of garnishment. You said the judgment has been paid and that there shouldn't be a garnishment. So have you received a satisfactory judgment? What do you mean when you say it's been paid? So go ahead and talk to me.
Only thing that I can say is I got money taken out of my taxes. I never received no letter from them saying they received none ever since 2006. Every year it just get higher and higher, and they just keep on taking money out.
Yeah, you do have a situation that started in 2006. So this has been around for quite a long period of time, and that will accrue some interest and things of that nature. So, Mr. Perry, what balance do you show regarding this matter, sir?
Yeah, sure, Judge. The current balance is $2,294.32. We did provide an affidavit outlining the court costs and the interest on this judgment. I would note, Judge, that there's been no payments made on the judgment since entry.
I have paperwork saying that they have received payments. There's no way you can't receive payments, and they're taking it from the state. They're taking it out of my tax. How you can't receive the payment?
All right, so you have, you're saying that you have some documents that show that payments were made sometime
Every
between
year,
Are you listening to me?
they-
Are you listening to me? Do you have documents showing payments were made between 2006 and the present time? In this case, that's what you're saying?
yes.
Okay, so you want to submit those items to Mr. Perry because that's ironic because they're not showing that any payments.
Judge,
have
I
been made.
think, pardon my interruption, Judge. I think the issue is we received a state disclosure in April indicating that they're holding the amount we requested in the writ for tax garnishment. The state of Michigan's holding $2,249.65. We haven't received that money yet, Judge. They hold the funds for about 28 days before they mail us the payment. And I'm assuming perhaps because Mr. McClendon filed the objection, perhaps they're waiting on an order from the court. But if we receive that money, and once we receive that money, Judge, we will consider the judgment satisfied. As it relates to his objection, today, it's plaintiff's position he's filled a state of valid basis to object to the garnishment. To date, there's been no money received. And we're asking the court to deny the objection, allow that money to come in and satisfy the judgment.
Yeah, so
I have-
Mr. McClendon, you're talking about the money that you received, a notification that they're going to take that money. That's what you're talking about?
Yes, for years. And I went to the court building and they gave me paperwork and outlined every year they garnish for me.
All right,
Every year.
So it looks like there is some disagreement whether or not payments were made or received in previous years. And so if you'll submit those documents to the plaintiff, to their attorney, they will have to take that into consideration, but their records are not showing that they received payments. So I don't see a bit of garnishment. So the funds to be applied. I will also require the issuance of accounting regarding funds received, regarding any charges to the account, and certainly nobody wants to take from you more than what is due under the judgment. So if you're able to establish that they received money previously, then you would be entitled to a credit. At this time, I find no valid objection to the writ of garnishment as the judgment appears to continue to have an outstanding balance. Right, that is my order. I wish both sides well. Good day to you.
Thank you, Judge.
All right, this is case number 16-107-981. This is Credit Acceptance Corporation versus, last name is Pearson. I believe this is Madeline Pearson. On the matters before the court on the following no objections to a writ of garnishment, the record should reflect that a judgment was entered in this matter by default on the 21st of June of 2016. That default was in the amount of $10,489. The plaintiff seeks to recover based upon that judgment. All right, your appearance for credit acceptance, please.
Good morning, Your Honor. Cezanne Barda, P65425.
All right, thank you, Mr. Barter, and good morning to you. I'm looking for, I believe it's Gwendolyn Pearson. If you're on the Zoom, please say something at this time.
It's Mendel Pearson. Thank you.
All right, thank you, Ms. Pearson, and good morning to you. I see that you note your objections that you did not live at the address in the car was sold or paid off. Ma'am, those would be objections that would have had to be raised at the time that the case was initiated. This is a post-judgment hearing. The only issues that can be raised in the post-judgment hearing is in relationship to the garnishment, not in relationship to the underlying judgment of this matter. So tell me what you're trying to convey to me about this stuff.
So I bought the car in 2014. I got into an accident 7 days later. They got the car, repaired it, and resold it. They've already taken about $2,700 from me based on after selling the car. So I'm trying to figure out how it is I still owe money, and the car was sold off already. And I was unaware of any of this because I haven't lived at any of the addresses that they have on this paperwork in over 7 years. So I'm confused because the car was paid off, was fixed and resold. And they've taken money before, and now they're taking money again. And they're taking twice the amount of the actual car note.
All right, thank you, ma'am. Mr. Barrett?
Your Honor, like you said, there was $10,000 judgment back in 2016. Just for the record, defendant filed a motion for installment payments in 2018, which was granted at $130 a month. She never made one voluntary payment. 4 to 6 months later, we filed a motion to set aside that installment payment order. A year later, in 2019, she filed a motion for installment payments, asking to pay $100 a month. That was granted. She did not make one voluntary payment. We had to then come back 4 months later and file a motion to set aside the installment payment order. So she has known about this. Obviously, this is earning interest at a rapid rate. Like you said, the judgment's in place. So unless she wants to file a motion to set aside the judgment, which is not what we're here for today, this is just an objection to garnishment. I would ask for her objection to be denied.
This car was off. This car was redone. And so
Let me stop you. All of that is stuff that's in the deep past. You are supposed to come to court and challenge that at the time that the case was proceeding. The court rules specifically do not allow the court to go back and to look at those matters in the context of a post-judgment hearing. The things that you're talking about are pre-judgment matters. That's when the case was filed against you. I have a proof of service here saying that you received service of this matter back in May the 9th of 2016 at an address on Hubble Street. Moreover, you already filed petitions for installment payments over and over again, and you refused to make any payments. This is a judgment that's against you. And you still 10 years later can try and file a motion to try to set that judgment aside. That's not in front of me today. What's in front of me is whether or not the plaintiff has the right to go forward with the writ of garnishment. The things that would stop that would be you file bankruptcy, or that the judgment is already paid off, or that there is an installment plan in order, things like that. None of that is the case here. What you're doing is you're relitigating the underlying case that you did not respond to. I can't let you do that. So I don't see a basis for the objection to the writ of garnishment. You have not stated any basis for that whatsoever. So first of all, I have to find that the objections in this matter are simply invalid at this time. Plaintiff is entitled to relief therein. Now, I know that you mentioned the garnishment rate. Of course, it would be 25% of whatever your take home is. So under the garnishment, that's the right that the plaintiff has, is 25% of whatever your take home pay would be. What do you get paid? Twice a month?
yes.
All right, and how much is being taken each pay period?
Over $450.
All right, so your rate is about $900 a month. You've got a big judgment here. So what would you like to pay a month, ma'am?
This car was paid off already. I don't want to pay anything a month. They got their money vehicle already.
Your Honor,
Alright,
if I may, whenever you have a moment, I'd like to say something as well.
Go ahead, sir. I'm getting ready to sign this order. Go ahead.
Your Honor, if she wants to go ahead and file a motion for installment payments and then we can respond to it, I'd rather have that. I don't even think we can entertain an installment payment order whereby there have been many previous installment payment orders where not even one payment was made. And now when you ask her how much she wants to pay, her first thing is, I don't want to pay anything. I don't know anything. It's telling me she's not going to pay on an installment payment order. I've been doing this for 20 years. I rarely don't give people a second or third chance. But this one is so egregious in the prior installment payment orders with not one payment being made. I would ask for just
You
the
have sold
objection.
that car for over $8,000 and two.
I guess, Ms. Pearson, you figure that you can talk whenever you're ready to, without it being your turn. So I had to shut you off. But here's the long and short of it. The long and short of it is that Ms. Pearson had certainly been given chances to pay, whereas she asked for chances. She asked to make installment payments, and she was granted that. And she did pay. Now she has a garnishment. I was not asking her about setting her up on an installment plan, not at all. That at this point, she's proven over and over again that she's not going to keep an installment. What I was attempting to do was to reduce the garnished amount so that she's not facing $900 a month. But she says she don't want to pay anything. She's going to remain under the garnishment. It was just matter of whether it's going to be, say, $500 a month as opposed to $950. That's the only thing the court was considering. But she's stated her posture that she doesn't owe anything, so I can't give her any relief there. So the objections to the writ of garnishment are denied, and the garnishment will continue. I wish both parties well. Good day to you. All right, this is case number 18-166-913. This is Credit Acceptance Corporation versus Kiara Scott. The matter is before the court on the following objections to a writ of garnishment. This garnishment arises by virtue of a default judgment that was entered on the 2nd of January 2019 for $10,360. Your appearance for Credit Acceptance Corporation, please. For Credit Acceptance Corporation. All right, do I have Kiara Scott, please?
Yes, you do, Your Honor.
All right, thank you, Ms. Scott, and good morning to you. I reviewed objections to the writ of garnishment. You indicate you never received anything by mail, say I'm being garnished. So you don't have to really receive anything by a mailman. You would be notified certainly through your employer regarding this garnishment. What are you trying to tell me?
No, so, well, basically, I didn't know that, excuse me, I didn't know that I was being garnished until I received the email through my employer. And I basically, just want to know what I'm being garnished for, and if they can, provide me with documentation, um, with a signature of mine or anything, telling me, what I'm being garnished for. And then they have already gotten 15, I think it was like $1,500 from me last year. I did come down to file a motion for installment payments. But I didn't know that I had to send the payments to them. I thought that my employer would, take that out my check and send it over to them. Your Honor, this is my first time ever going through something like this. So with the installment payments, I did not know that I had to pay them. But if I can, do it over again, that would be great, to where since I do know that I have to send those payments in, they will receive those payments from me instead of them garnishing me.
All right, now, so, ma'am, if you were going to raise issues with regard to the underlying case, you would have had to do that at the time that the complaint was filed. And you did file a petition, as you indicated, for installment payments. I granted that petition, and you did make the payment, so it was set aside. But on the granting of your objections, excuse me, on the granting of your petition, I indicated on the phone, on the form, I should say, that the payments are to be made to the plaintiff, to the plaintiff's attorney. There was no direction for payments to be made from Blue Cross, and this was back in November, excuse me, October of 2024. The objections that you stated here, that you never received anything, that's not a valid objection to the writ of garnishment in this matter. I can't find any validity in such an objection that doesn't give the right to stop garnishment. Now, how much is being garnished from you each pay period?
I get paid every 2 weeks, so they're taking 25% of that. So I think it's almost like $400 that they're taking out.
Okay, so about $800 a month is where you are.
Yes.
And you got a $10,000 judgment, over 10,000, and that judgment has been in place for 5 years. So you got interest for it. I know that you indicated that you were garnished for 1,500 or so last year. That would be applied and reduce it some. But you got a big amount here, and that they're going to keep coming after you because of the magnitude of the amount that you have. You had the opportunity to pay under that voluntary order. I mean, that was your best shot at it. So I will take into consideration the issues that you have raised now. But you gotta stay under the garnishment.
Mhm.
And so I will cap it at 150 per pay period. So the garnishment will be up to 150 per pay period. So that's going to hit you for about $300 a month. Otherwise, I'll leave the garnishment in place under these circumstances. I do wish you well, ma'am. Good day to you.
Thank you.
This is case number 23-149-129. This is Albia funding versus Pamela Townsend. The matter is before the court on the following of objections to a writ of garnishment. This is in relationship to a judgment that was entered in this matter on the 20th of December 2023. That judgment is for $6,385.08. Your appearance for Albia funding.
Thank you, Judge. May it please court, I'm Attorney Richard Rusin. I'm the attorney of record plaintiff, my bar number 35222. Today, I'm also the respondent to defendant's objection to an income tax garnishment.
All right, thank you, Mr. Rosen, and good morning to you, sir. I'm looking now for Pamela Townsend.
Yes, I'm here.
All right, thank you, Ms. Townsend, and good morning to you. I looked at your objection to the writ of garnishment, said you were unaware of the debt until you received a garnishment from the state of Michigan. It looks like this matter, the judgment was entered, as I told you, in 2023. Looking at the court's file, I have a proof of service document that was allowed by alternate service at the Coyle address, and that was back in July the 8th of 2023. That's how we got to the place where a judgment was entered when there was no response to the complaint. So that's before, that is a pre-judgment stuff. We're already past that. But now in post-judgment, this is the collection part. And so I don't see where that is a valid objection. So what are you trying to tell me? Then I'm going to hear from Mr. Rusin from the plaintiff's perspective.
You're hearing from me first?
Yes, ma'am. Go ahead.
Okay. Now, it didn't say anything about Home Depot or anything like that. I didn't know, it's so much fraud. I didn't know who it was from, what they were talking about. And because I know I had paid down
I had old Home Depot. And when I tried to reach out to Mr. Richard Grusin, the number that's on the paper is a non-working number.
All right, now, let me hear from Mr. Rosen at this time, sir.
Judge, I have no idea what the defense is actually talking about with protecting the record. I can only rely on the restorative actions. And the court has already made the observations as to the amount of the other lawsuit, how the summons was served, and the entry of judgment. I can tell you, Judge, as an officer of the court, that the original matter that is subject to this hearing today is an assigned debt, more or less the first assignment, whereby the defendants had, according to the records of Citibank, had a Citibank credit card that was opened by defendant January 21, 2020. Payments were made, charges were made, then more charges were made, and then the matter was charged off on or about August 8th of 2021. It was assigned LBNB funding, more or less as the first assignment, to recover the unpaid Citibank credit card balance of $6,116.85. So that's pretty much what I can tell you, Judge, from the register of actions and also my own records from Citibank. I can tell you further that when I reviewed the Citibank credit card statements that Citibank assigned to LBNB funding in my office before I came down here today, I see that all the credit card statements went to defendant at the same Coral Street address that she's filed her objection to the garnishment. So, Judge, I ask that you deny the objection to the income tax garnishment pursuant to MCR 3.101K.
All right, thank you, counsel. So, ma'am, I don't see a valid objection to the writ of garnishment. There was a judgment that was validly entered. That judgment remains in place, and there is a balance on the judgment. As long as that is the case, the plaintiff would have the right to proceed by way of collection. And this is one of the ways that that's done through the tax garnishment. I don't see a valid objection. For that reason, I'll find the objection is invalid. And any funds withheld will be released to the plaintiff to be applied towards payment on the outstanding judgment. You certainly can reach out to Mr. Rosen's office. That information would be on the paperwork that you fill out. I know that on that document, I see a number 586-868-2727. Actually, that should be 2737, I believe.
Yes.
That should be 2737. So if you look at your documents, ma'am, make sure you're using the 2737 at the end. So 586-868-2737. I know you had down something a little bit different, but if you use the 2737, you should be able to reach Mr. Rosen's office, and you could talk further about ways to try and resolve it. But at this point, with the valid judgment in place, they certainly, that is, the plaintiff certainly has the right to collect based upon that judgment that was there. That is my order. I do wish you well. Good day to you, ma'am.
Excuse me, can I ask you a question?
Sure.
Okay, now you're saying the judgment is that he takes my income tax for $1,300?
Yes, and apply towards, not he, the company, LBNB funding has a right to take that money because of the fact that they have a judgment that is in excess of that amount.
Okay, and again, the I had paid off or down, and it was never $6,000 because even on the Home Depot, I never had anything to do with Citibank. I had a Home Depot card, as I said before. I never.
Well, the problem is, ma'am, is that you did not respond to the complaint, and the judgment was entered as it is entered. If you believe that there is something about the entry of that judgment that is improper, you certainly have the right to file a motion to try and get that judgment set aside. And of course, that's been a few years ago, but you can always file a motion to try and get it set aside. The thing that I would, of course, suggest that you do is contact Mr. Rosen's office, ask for an accounting, a breakdown of what the charges are, and then review that. And if you believe that that the numbers are consistent, then try and reach an agreement as to how you're going to pay that, so that you don't deal with the garnishments.
Okay,
You can reach.
okay, okay, and also, as I was getting ready to say, the statements they were sending me, they were asking if you're having any problems with paying because of COVID, and that's what I signed up for. I was having problems paying because of COVID. I moved back here from Florida because of a tornado. They gave me a card. I bought a home, trying to fix it up, and I don't owe that much money. I gave them my life savings. I came here with 2 jobs, end up having none because of COVID. All I had was my life savings.
Ma'am, I understand everything that you're saying. And it sounds like what you'd like for me to do is to make this go away. If I had a lawful way of doing.
No,
Excuse
I
me.
apologize for interrupting, but not go away, but to make, okay, I know I owe something, but the card wasn't even $6,000. They didn't give you $6,000.
I understand, ma'am. And what did I tell you, were your alternatives in that regard? So you want
Okay.
listen, I don't mind you telling me that 3 times because you've already told me that 3 times. I told you that you were supposed to the complaint that was filed against you a few years ago when they brought the case and addressed it at that time. But I also told you that you also have the right under law to file a motion to try and get that judgment set aside, and you can raise in that motion the issues that you believe you should raise. And if there is a legal basis and a factual basis for setting that judgment aside, then you have a chance. The longer you wait, and depending on the circumstances, there may not be a legal basis to set it aside. And if there's not, then the judgment is what it is. But at this point today, none of that is before me. The only thing before me today is that there is a judgment against you, a complaint that you did not respond to. As a result of that, a judgment was entered, and today is really about collection of that judgment. That's the only issue before this court, is whether or not the plaintiff can collect on that judgment. And because it is a validly entered judgment, they have the right to collect. They can use garnishments of bank accounts. They can use garnishments of income tax return. They can use wage garnishments. They can use a tax on profit. A number of different things that can be done because there's a judgment in place. That judgment is everything.
Okay.
So that's by determination. Alternatives. One of the things that I mentioned in finality is that you may want to reach out to Mr. Rosen's office and discuss this in more detail to try and figure out a way to get to the conclusion on this. Maybe you can negotiate a lower amount with a larger payment, all kinds of things. But you have to reach out to that office and try to talk about that to see if there's a way to resolve it. The problem now is that there is a judgment that's been in place for several years now. All right, all the best to you, ma'am.
All right.
Thank you. Good day to you.
You too.
Mr. Rose, you have other matters?
Judge, I have one remaining matter on the docket today. The last 4 numbers are 2136.
I'm sorry, the last numbers of what?
Oh, no, this is another case, ma'am. You're all set.
Okay, thank you. Get out of here.
Hello, I was wondering, was my case being seen?
When I call it, it'll be heard. This is case number 22182136. This is Credit Acceptance Corporation versus Sharday Lane and Tina Lane. The matter is before the court. I don't see much paperwork in this regard. It looks like there is an objection to a writ of garnishment in regard to that matter. Your appearance, Mr. Rosen.
Thank you, Judge. May it please court. I am attorney Richard Rusin. My bar number is 35222. I'm the attorney to the plaintiff, and today I'm also the respondent to defendant's objection to an income tax charge.
All right, thank you, counsel. I do see that a judgment was entered by default in this matter in 2022 for $12,345.57. Let me see if I have Miss Sharday Lane. I have Sharday Lane on this matter. All right, that I believe that Miss Sharday Lane is the petitioner. It does not appear that she has appeared regarding this matter, Mr. Wilson.
Yes, yes.
One second.
She was there. She was on the telephone. She was on the telephone.
So I don't see her there now. Maybe she dropped off. Let me see. I don't see her coming in. So, Mr. Rose, I don't even have a copy of the objection to the garnishment. Do you have?
I do. Can I present it, Judge?
Yes, if you would, sir. All right, I'm happy to receive this. I'm looking at the objection stated on the form. The defendant says that, Ms. Lane says that she lost her job and need her funds for bills. All right, sir.
Yes. Judge, may I respond?
Okay.
Judge, I reviewed the objection filed by defendant's matter, although I'm sympathetic to defendant based on her circumstances. Unfortunately, what she's alleged to object today to place on your docket is not one of the matters which is legally allowed under MCR 3.101A. Therefore, and coupled with the fact that defendant has failed to appear both in person and by Zoom to prosecute her objection, I ask you.
All right, I have noted that despite the court having given a notice at the time that the defendant filed the objections, she was notified to be here at 10 o'clock a.m. for the hearing on the objection. She has not appeared. Moreover, the defendant petitioner has not stated a valid objection to the writ of garnishment. There is no objection that would be allowed by virtue of loss of job. For that reason, the objection to the writ of garnishment will be denied at this time. And of course, the court knows that the defendant is not, petitioner is not present as well.
Thank you.
Any funds withheld will be released to the claim.
All right, thank you. I'm not here for your docket. I'm here for that other Coleman's docket.
That's okay. It's good to see you. I don't get to see you with the shutdown and stuff. We've worked together years and years, you know.
Oh, yeah. Well, you know, the thing it is that if I've got a contested hearing, although Judge Coleman's docket is not contested, just to confuse a little lady, but you know, if it's really contested, I prefer to show up in person because that 6-second pause when the people are over.
Yeah, and sometimes we forget about it, but.
Yeah, and I gotta tell you, a lot of district judges I've appeared before all throughout the state, they have not mastered the art of the mute button that you have, which I think is important, and because you gotta keep control of your docket.
It's seriously important. You gotta be able to manage that whole part of it for sure.
Oh, yeah.
Well, you know, I'm leaving. I have been offered by the Supreme Court, the Region 1 Administrator.
Oh, how about that? That's great. Oh, gee, now I got two of my favorite district court judges leaving, you know. I wanted to go down to Judge Sabri's office and give her some of the best judge I've ever had, to be honest with you, is the circuit court judge, Richard Kaufman. He's on the district, and he would have his civil docket on Wayne Circuit Court, and I thought this was very insightful. He'd call the case, have two attorneys go up in front of him, and he'd say on the record to the respondent, quote, "I've read the petitioner's motion, now tell me why I should grant it." I thought that was splendid, you know? And then there's a current judge up there now, this was before about 2 weeks ago, that if there's a non-contested motion, her clerk says, you don't have to wait around, the judge is going to send you a written opinion in a couple of days, which is great,
Right.
you know? So anyways, maybe you should tell that other judge at Harvard Woods. Well, congratulations, Judge. That sounds like a real great promotion.
All right.
All right, we'll see you.
All right, take care. Good to see you. All right, this is case number 23163-486. This is Advanced Pain Care PLLC versus Ashley Jeanette Blackshear. The matter is before the court on the following objections to a writ of garnishment. The writ of garnishment is a relationship to the Michigan Department of Treasury. All right, do I have anyone from Advanced Pain Care on this Zoom? All right, do I have Ashley Blackshear on the Zoom?
Yes.
All right, thank you, Ms. Blackshear. Good morning to you. This matter is before the court as a result of a judgment that was entered by default on the 13th of March of 2024. The judgment was entered for $7,979.30. The garnishment is the plaintiff's effort to collect on that judgment. You filed and you indicated that you never were served and I've never been to a pain doctor. That's the nature of your objection. Is that correct, ma'am?
Yes,
All
I'm
right.
not understanding why I'm getting garnished because I never went to a pain doctor and I never was served. It said I was served. Personally, no one ever gave me a paper or served me. I was just now notified through like when I filed my tax that I was getting a garnishment. That's how I found out about it. So I immediately filed an objection to it because I'm not notified about none of this. And then I also have proof about my identity being like stolen. I have like PPOs and police reports about that. And they said this was like in 2018. I was like 18, 19, and I was still in high school living with my parents. So I'm not understanding how I was going to a pain doctor.
All right, ma'am. So the the way that this thing proceeded is that a complaint was filed against one Ashley Jeanette Blackshire. That complaint was served on that person based upon an affidavit submitted to the court on the 8th of January of 2024 at an address on Stansbury, 15480 Stansbury, Detroit. The document says that the person was a age 24. It says that she's white, height is 5'6", and weight is 135 pounds. That she does not wear, hair is black, she does not wear glasses. So that's the information that brought this to the court. As a result of that, when there was no response to the complaint, a judgment was entered against you. And that judgment is why there is a garnishment. Now, what you're doing is you're trying to attack that underlying judgment by objecting to the garnishment. You can't do it that way. You you likely will want to file something to try to get that judgment set aside. Because as long as that judgment is in place, the plaintiff has the right to go after your assets because there's a judgment against you. Let me ask you a very simple question. Does that description on the service document, does that description fit you?
No, because in 2024, I was pregnant. I was not 132 pounds. And also 154, the address 15480 Stansbury, that's my old house. I don't even live there. I didn't live there in 2024. So.
Are you a white female?
Huh?
Are you a white female?
No, sir, I am Black.
Well, see, you probably want to file a motion to try and get this set aside. I'll give you the description of the person that they say they served on that date. They say that they served a person age 24 in sex female, race, skin color, white, height 5'6" and weight 135 pounds, and that person wears glasses.
No, that is not me, sir.
Well, what you want to do?
I can show you my face on Zoom now. That is not me.
Well, and what you got to do then is you got to go back there and you probably got to file a motion to set that judgment aside and indicate that that you were never served, that you are not the person described. It describes a white female, you're not a white female, and other issues. And if that is set aside, then that will get the judgment set aside. So I can't make those decisions today because that's not in front of me. What's in front of me is the post-judgment stuff. And that is regarding the writ of garnishment. So what I'm going to do, in relationship to the writ of garnishment, at this time, I don't see a valid objection because I can't go back to the judgment. I can only go with the fact that there is a judgment. So I don't see a valid objection to the writ of garnishment But what I'm going to do is,
So that mean I would have to pay money that I haven't, I'm kind of confused, like
don't,
this.
don't be confused. Don't be confused, because what you're about to do is you're about to say something that you know don't make sense. So I need you to hear what makes sense. What makes sense, that there is a judgment against you. It may be that that's not you, so you got to go back there and undo that. But because right now there's a judgment against you, the plaintiff has the right to collect on that judgment. So the thing that you need to be focused on, I think, because I can't give you legal advice, the thing that you need to be focused on, getting that judgment set aside. Because if you don't get that judgment set aside, this is gonna happen over and over again, and if you work anywhere, they don't come for your wages too. You sound like you got a good case for getting that judgment set aside. So you wanna file something ever so quickly and put in there the identity theft stuff that you talked about. The most important thing that you want, or maybe not the most important thing, but very significant that you want to put in the document is that you are not a white female, and the document says that they serve the white female.
Right.
Now, could you pass for a white female?
No,
Why don't you come on the screen and let me see?
I'm trying to do it. How do I, okay.
No, you're not pass for a white female. You are, and not a chance.
But I am, yo,
I mean, you need to file a motion to the judgment set aside. I can't do anything about the garnishment because the judgment is in place, but you have a good basis for trying to get that judgment set aside. So what I'm going to do is I'm going to suspend the garnishment for 30 days to give you a chance to get that paperwork in, so the other side can respond to it. And again, go online and get a copy of the. You can go online and get a copy of the proof of service. Proof of service document is a document that lists the identity of the person that they serve. Again, that document says it served a white female,
okay,
5'6", 35 pounds, and wear glasses.
okay, that is not me.
It doesn't look like you. Doesn't look like it to me. Okay, but you gotta file to try to. That's the part that you gotta attack. You're attacking what happened after the judgment. You gotta go and attack the judgment, and you got a good reason to attack the judgment, because that judgment, that service does not identify you. It can't be you. Okay, so get that in right away. And then a hearing will be held on that. They'll set you a hearing date. So you want to file a motion to set the judgment aside because you are not served, and the person served is not you. It is a white female.
Okay. And how do
Raise
you
it.
do that?
Well, you came down here and filed your objections like that.
Okay,
This time you filed a motion to set the default judgment aside. Okay? All right? All right, get that done right away.
okay, so with the garnishment, so they still can take my money from my taxes stuff, and if my wages, if I did get a new job and stuff like that.
The money that is attached right now from the Department of Treasury, I'm going to suspend it for 30 days. I mean, you can't take it for 30 days. In the meantime, you're going to do what you got to do. Okay? And the sooner the better, because if you work somewhere and they find out where you work, they're going to file a garnishment against your wages. So you need to get that judgment set aside. If you get that judgment set aside, that's the end of this. And you should be able to get it set aside, because once again, the description is certainly not you.
Okay,
That's a big deal. I rarely ever see that. So the process server said that they served a white female on Stansbury Street. And that's clearly not you.
right.
Right? So, so get your paperwork in, your motion to set aside the judgment so that you can get a hearing. All right?
Right.
All right, I wish you well, ma'am.
So much. have another question.
Go ahead.
Okay, so when I filed my motion, to set aside for default, so I have another court date within the 30 days that you, put the funds on hold. And then the next time I come, I would have to like provide all my proof and everything.
Get that paperwork filed right away, all right? So I'm suspending this until July the 7th. I want to get your paperwork filed as quickly as you can, so you can have a hearing on setting that judgment aside, okay?
Okay, perfect. Thank you so much. And will I come back in front of you?
No, I'm retiring, a different job, but I'm leaving good notes, so they'll know exactly what to look for, okay?
Okay, thank you so much.
All right, thank you. Good day to you.
Good luck, your new journey.
Thank you. Right.